Mr. Phillips?
Yes, Your Honor. Thank you. Good morning. And I thank the Court for taking this on direct appellate review. It really expedites it for my client. I appreciate it. Your Honor, this case, Ms. Pelletier won a verdict on a sexual harassment claim down in Bristol County for $1.87 million. The judge, after trial, remitted the verdict to $300,000. And then upon reconsideration, increased the remitted to $600,000. Ms. Pelletier at that time accepted the remittiture and sought to end the case. The defendant appealed the remittiture, and one of the primary issues that we've appealed on is whether a plaintiff on appeal can revoke their acceptance of a remittiture when the defendant appeals.
Is there footnote 4 of the Badaza case?
Yes, Your
Does that address that?
It doesn't address it.
What does it say?
It says, in essence, it notes an exception to the rule where if a situation occurs where the defendant appeals after the plaintiff accepts it, notes the exception in other jurisdictions. And that's it. The Baldanza didn't directly address that issue.
So other jurisdictions allow a person to withdraw their acceptance.
Yes, Your Honor. We've cited a number of jurisdictions in our brief, and a leading case started.
Are there others that don't allow it as well?
There's some that are statutory. The legislature's acted on it. There are some that may not have ruled on it. We believe the way to go in this circumstance, given and I'll tell you exactly what happens here. The plaintiff at the end of the road gets this verdict and thinks she has won. It gets reduced, number one. And you have to have the conversation, look at your client, how can we get that verdict back? We can't get the verdict back unless we go through another trial, a new trial, and then appeal after the new trial and come up to the appeals court. So the situation is, do they accept the money? And here we have her claims were harassments in 2000, we're in 2008, and she's destitute, she accepts the money. That's what happens in reality to a number of plaintiffs. They basically, how the game is over, they've been waited out, they need money. So she accepts that amount and gets none of the benefit of that acceptance. She still gets an appeal, she still gets the delay, and she still gets all that in the process. We're only asking that the slate be clear. Well, and this is another tremendous thing that happens to a plaintiff there, is that leverage tips tremendously to a defendant. The plaintiff had won at trial in front of a jury, and all of a sudden their damages are now capped if they accept the $600,000. So if you're going into a settlement negotiation, which happens post-trial, we all know, all of a sudden you're capped at the $600,000. Unless there's a situation in place where the plaintiff, when the defendant appeals, can revoke and put her cards back on the table.
But you're saying it's not fair. Basically, it's a fairness argument.
It is a fairness argument. In the cases, they cite expense, delay, and uncertainty. That's the reason why a plaintiff should be able to do this. I mean, the delay is obvious. You know, she's been waiting a long time for her money, in essence, to get anything, and she has to go through this appeal, and then if we go down, possibly another trial, and then who knows, another appeal. So while we're here, let's discuss the theory is let's discuss the entire verdict and whether it was right to remit it in the first place, because we're here. And one of the issues, one of the reasons is judicial economy. I know that's kind of like a cliche, but in this circumstance...
No, it's not in this court and in this Commonwealth.
Well, in this circumstance, it really does apply, and it applies forcefully because we'd have to go through the process twice. That's what happens in reality. She gets no benefit of that bargain, that acceptance of the remitted, waiting for the case to end.
Could I
yes.
shift to the within the scope of investigation rule?
Yes, that was the next. That was my two topics I was going to talk about. I was going to go to that next issue.
Yours, and maybe I just missed this. I'm trying to. You're saying that the whole hostile work environment and going back in time was within the scope of investigation because of a reply brief?
Not just because of a reply brief, Your Honor.
Affidavits that were filed?
The affidavits were, a memorandum of law was filed, and it had referenced, can I just back up a little and let's tell you the facts of how this case, my client, you know, and it's in the record, it's all supported in the record, goes through years of abuse and goes up to MCAT. She's at the end of her rope. She's diagnosed with major depression, post-traumatic stress disorder by her psychologist, and he testified at trial. and she's at the doorstep of MCAD, and she's complaining. And we all know, and Dr. Curran testified at trial, you have memory problems, you have concentration problems when you have post-traumatic stress, major depression. She files her MCAD claim. She sits with a representative there and goes through the claim and puts a claim down. And we brought it up at trial, and we put it to evidence. I think her claim is pretty good, alleging that she's a lesbian and that she's treated differently by the town of Somerset.
And the supervisor?
And the supervisor, and alleges 2 incidents, and says there's a pattern of her being
Now,
treated
could you
differently.
just clarify, was she represented by counsel?
At the filing, no. Afterward,
But she did have counsel.
correct.
I take it that, let me just ask you the question. Mr. Phillips, if she had gone to the MCAD and for a variety of reasons not wanted to disclose her sexual orientation,
Yes.
and she had said, I was harassed, I was a woman, I was the only woman there, he was constantly, there were videos, there was pornography,
Yes.
I was getting told, you just want what the boys want, all of which could be applicable to a woman, but she'd never said anything about her gender orientation.
Yes.
I take it that if she had used all of those same facts when she filed in the Superior Court, but now was claiming a violation of gender and sexual orientation, that would be a different claim, correct? If she
had not mentioned it at MCAD?
she never mentioned it at MCAD.
I don't know if your example is she doesn't mention the sexual orientation, but just
That's a
mentions
different
gender.
claim. It's a different,
Correct.
violation. Now she says it wasn't because I was a woman. It was because I was a woman of a certain sexual orientation. And the defendant comes in and says, "Now come along. I didn't have a chance to defend her. I didn't even know she was her sexual orientation. I didn't have a chance to defend that." And it's a new claim. It seems to me. We have to give. She did mention. I'm not asking.
Okay, I know. That's why it's tough to go down there. It's similar to Clifton, where he didn't mention a hostile work environment claim, and the court said, well, it's related enough that
No,
you
but
can have
I'm
that.
looking at 2 very different kinds of things. I'm looking at it from the point of view of the employer.
Okay.
Namely, if I'm having to defend on a ground of gender discrimination, or I'm defending on a ground of gender and age, or I'm defending on a ground of age and race, and at the MCAD, the claimant is only mentioning one.
Yes.
I can understand why that is a separate claim, even though the underlying facts may be the same.
Okay.
Here it seems to me that essentially, at least one way to read Somerset's view is that you have to specify every single episode of what constitutes this pattern of harassment,
Yeah.
correct?
And that's interesting. I think that was rejected in Cudger. Resoundingly rejected. Because if you look at the facts of Cudger, just draw a line down your legal pad, put the facts of Cudger and the facts of Pelletier, they almost identical.
But Cudger, the issue wasn't the scope of investigation for purposes of whether administrative remedies were exhausted, was it?
No.
It didn't come up in that case. But
Right,
what
this is
else?
a very different issue.
It's not that different, Your Honor. You can look at it both ways. I think the trial judge initially, through the trial, did the right job. Gave an instruction on the continuing violation doctrine, actually before we even started the trial to the jury, and then again at the end. Okay? If you look at Cudger, our case is almost exactly facts, everything just like Cudger, including complaining and not getting relief, including only putting a couple of identified claims in her complaint, and then the court allowing at least those facts to come in for damages or for proof of hostile work environment. I don't even think we reach the scope of the investigation rule because the continuing violation doctrine applies.
But isn't the Somerset's claim that it's one thing to say that, and I'm blocking on his name, the supervisor.
Cabral.
Yes, Mr. Cabral did X, Y, and Z. It's another thing to have this expansive view of the hostile work environment. And so it is a different in kind claim. Cudger, that wasn't the issue in Cudger.
I don't think it's different in kind of claim. I would say it's different in facts and development of the facts.
I'm not saying I agree with that. I'm just saying that is what they are arguing.
I understand what they're arguing. If you look at the situation, and what
Was there evidence before MCAD? I'm not talking about her complaint. I'm talking about when the MCAD proceeding. Was there evidence of pornography?
there was
Was there evidence of videotaping?
no.
Not videotaping, or video.
No, her continuing investigation revealed that.
Okay.
What had happened, she had, her lawyer was replaced. There was a more vigorous investigation done. And as things developed and as actually you talk more to a client who has put, one of the hardest things as a lawyer is to even counsel or talk to or bring to trial to testify a client who has a psychological injury. It's almost nearly impossible to get their story out in any short period of time. You have to work with that client for a long time. So when Cudger says you look at things in hindsight, well, her hindsight took a lot longer for her to put pieces of the puzzle together. I don't think she should be punished for that because the defendants in part caused that on her. I mean,
Well, can you clarify for me, was her MCAD complaint focused on just her supervisor?
you can read it both ways, Your Honor. After me hearing the evidence, you can't read, I don't think you can read that in a vacuum. Because if you read it without a hostile work environment and knowing what's happening, the forbidden fruit comment, for example, may be benign. But it's not benign. And saying to tie yourself to a chair may be benign. But if you look at it in the backdrop of never reprimanding anybody and putting this foreman in a position to say such things to her, to make such comments to her, there it becomes a sexual overtone regarding the forbidden fruit, which on its face is disparate treatment. You don't get what the men get. I mean, the comment itself is disparate treatment. And then tying yourself to the chair, which he admitted at trial, he never said to the men. So if you look at things, I don't know how to say myopically, but if you look at things very linear and don't look at what really happened, sure. You know, it's like when they define in their brief, well, forbidden fruit means means the real definition of it. I mean, we have a lot of times in parlance walking around when people say things, take the word, bitch. Oh, I just called you a female dog. That is not how it's used in society. So subject to interpretation of how these things are used. So you can't just look at the complaint and say, I look at the word and say, they just read just like this, just verbatim. That's all there is here. So I don't think what happened was her investigation continued because her story developed. Every client's story just doesn't instantly develop as a lawyer. You get it straight up.
But this was all the way through discovery, interrogatories. I mean, 90% of this stuff didn't come out until there was a complaint filed in the Superior Court.
No, it came out in a post.
I would say 90% of it, Your Honor. What had happened was the evidence of the pornography was put in the memorandum of law, which was September of 2001, while the
evidence was put in, or it was referenced in a memorandum?
It was referenced in a memorandum, Your Honor. And then they acquired affidavits when they appealed and said, this backs up our prior contentions in the memorandum of law. Here's affidavits.
And is that sufficient to place it within the scope on appeal?
I think it is, because I think
What does the law say? Is it sufficient?
The law says once the lack of probable cause is issued, the investigation is closed. So whether you consider the affidavits amplifying and supporting the prior memo, they're raising a hand saying there's pornography here. Nobody's listening. So the story in the investigation develops over time.
But do you have anything in the MCAD, apart from that letter that was provided in the request for reconsideration the same day that you filed, that speaks to the issue of any pre-Cabral hostile environment, of hostile environment that began, that was going on before Cabral became her supervisor?
The September 2001 memo references a hostile work environment, references the pornography, references the disparate treatment. Now, don't forget, she walked.
I'm sorry, was that before or after? I mean, there was that
before,
during that was before or after Cabral's becoming her supervisor?
The pornography had been there for years. It had
Is that what the memo
said?
said?
Been there for a long
The
period of
memo
time.
say that? Because, I mean, because she testified everything was pretty good until Cabral came. So is there anything in which she said, actually, things were pretty awful, even before Cabral came?
That before MCAD, you're asking, correct?
Yes.
She had complained numerous times. Not before MCAD, no, because her investigation was developing. The issue is whether MCAD should have investigated or was put on notice to investigate. Not whether they did. Actually, they struck a portion of the memo, and they wouldn't consider the affidavits. They certainly were on notice something to strike it. So I believe, and we argue, that they should have investigated. Once you start investigating pornography, it's not far when you get to comments of calling someone a dyke. It's not far to get to the other incidents where people are being harassed at that workplace.
She is saying to MCAD, if I understand you correctly, if she's saying no, before Mr. Cabral, things were pretty good, why would they investigate?
Your Honor, I don't think that was her statement exactly about things were pretty good. I think one of the questions posed was, do you have any problems with anybody else? Now, there's another issue here which, you can't, it's difficult. I wish I could write a perfect brief and it wasn't so linear and you could actually, feel what the clients say in court. It's very hard to write it in the brief. Miss Pelletier is like I love her. She is like a Forrest Gump character. She cannot take anything into context. She testified at trial. I was lucky to graduate high school. I didn't pass the second grade. She was very happy to be working at the highway department picking trash. She is a wonderful lady, but she is simple, very unsophisticated. So if you ask her, did anybody ever call you derogatory names or dyke? She can answer that question. If you say, were you sexually harassed? That question she cannot answer. Actually, it's a statutory definition, as we tell Cudger. Until you know what the statutory definition of sexual harassment is, I don't know how you can answer that question.
Well, she did say that someone cupped her breasts, right? I mean, that's sexual harassment.
Correct.
She knew that. And
Correct.
she didn't report that, did she?
She did report that years before. Her testimony at trial was, on cross-examination, the transcript at 547, did not know what I had to say when she was with the MCAT. If I had known, I would have written it all down. I would have. So when she's sitting with the MCAT, she doesn't know to write everything down. She doesn't know she has to go back and do a litany. She probably, I don't know, because we're not there. We're not in that room with that representative.
She's got a lawyer. They file answers to interrogatories.
Yes, Your Honor.
I assume extensive answers describing what was at issue, right?
Yes,
so she's not just alone in a room with no one around and she doesn't know what to say. I mean, this is a piece of litigation in which she's represented by counsel. Her testimony is taken, her deposition is taken, her interrogatories. Virtually none of this comes up until the case is filed in the Superior Court. It's a whole new case. That's what the judge found below. Looking at the evidence afterwards, it's a completely different case.
Well, I don't think it's a new case, Your Honor. The claims are always the same. The claims never change. And you'll notice in the town's brief they talk about the claims. The claims were always the same. The facts behind the claims developed as the investigation developed. And that's what we have. And just take a look at Cudger. That's exactly what happened in Cudger. These facts just don't come pouring out in these kinds of cases.
But there's a difference between saying I was happy until Cabral came versus I was miserable even before Cabral came.
Mm-hmm. And he exacerbated it or whatever.
And then things went from miserable to unbearable.
Yes.
I guess the concern here is whether or not there was fair notice that you were also alleging that life was pretty miserable even before Cabral came.
Do you want me to answer? Can I know my lights are blinking.
Apparently,
you're
if I ask the
permitted to
question,
answer the question.
Okay. The whole notice issue, the town had known about the pornography for a long time. They admitted in the answers interrogatories for the Superior Court case that they knew before she filed their MCAT. It was their supervisor admitted that he knew about the pornography. It wasn't as if the town just raised their hands and said, whoa, we don't know about any of this stuff. Their own answer to interrogatory said we knew about it before she filed her MCAT. She went to the town select woman during this process before her grievance was heard and told the town select woman there's pornography at the workplace and told the town. So I understand what you're saying is, okay, but why didn't she say that at MCAT? I keep having to go back to this. You have this broken, battered person going to MCAT who's supposed to protect her, and the town had notice. The town had notice, and MCAT certainly had information enough to investigate. So all we're asking is that her story be told through, and we do a little more investigation. That investigation happened to happen in the Superior Court, but her story needed to be told. And there was enough before MCAT that if someone started poking around with the investigation, they certainly would have revealed this stuff and talked to some witnesses. Thank you. Thank you, Your Honor. Thanks for your time. Appreciate it.
Thank you, Mr. Phillips. Good morning, Mr. Dowd.
Good morning, Your Honor. May it please the Court, I am David Dowd, and I represent the town of Somerset in its Highway Department. I'm going to give some different answers to the questions that I just heard.
Well, could you just, it seems to me that Justice Gantz, I think implicitly, was saying the reason why we focus on what was presented to the MCAD, and by the way, you can, if it's notice pleading, you can file a complaint in the MCAD and then file it in Superior Court, right? So
I'm not sure, Your Honor, that the MCAD case law and rules and regulations have notice pleading as we would have under the Mass Rules of Civil
No, they don't have
Procedure.
notice pleading, but the point of having this jurisprudence is so that if the case that I mentioned, if somebody comes in and says, I was discriminated on because of my gender, right, and doesn't mention sexual orientation, the employer is going to do some investigation correct? The employer is not going to investigate, did you even know what her sexual orientation was? Was there anything said that was relevant to her sexual orientation? It's going to be none of that, correct?
You're correct, Your Honor. The issue is what is the claim that is brought to the attention of the MCAD?
Well, the claim here was sexual harassment, correct? And the claim gave as examples the conduct of her supervisor, correct?
I would respectfully disagree, Your Honor. The regulations of the MCAT are that you give the wrongs that were done to you, the dates they were done, and who did it. She did that. And
yes, I know, but if you have a continuing violation theory, if we are asking claimants to, at the MCAD, list every single possible one, even before there's been discovery, dates may be wrong. I understand why the MCAD is saying, tell me what you did. It's not too difficult if it's a claim of, I discovered that the men were getting paid more than I was, or I wasn't promoted. You know, there's a particular incident. With ongoing violations, it's much more difficult.
True, Your Honor, except that when we're talking about ongoing violation, I don't think that is the issue here. That was the issue in Kadire. I call it Kadire because there's an outfielder for the Minnesota Twins whose name is spelled that way, and he's Kadire. But the issue in that case was not scope of investigation. The issue in that case is whether a remote claim can become timely.
No, I understand, but in a funny kind of way, that is the case. That is the case because if, for example, it had been outside the scope, I mean, I understand it wasn't termed a scope case, yes. But certainly if it was outside the scope, because she hadn't mentioned these earlier things, in part, she had in some part, but not entirely, we wouldn't have worried about statute of limitations purposes.
Well, in that case, Your Honor, I would say that I do not believe that Pelletier at the MCAD raised a continuing violation claim. Her claim was very clear that she had been subjected to certain statements by her supervisor over a certain period. That was it. Now, then it proceeds to discovery.
Minute. Isn't that continuing violation?
No, it was over about 3 months or something of that nature, all within the anchor period and so forth. Her complaint says that in the summer of 2000 that Cabral had done this, that, and the other thing. It was 2 things plus a statement, actually. Now then, we can't look at just that alone. I mean, in the way you want to frame it, Your Honor, as what then became the scope of the MCAT. Well, in that case, let's look at the discovery. And in a different answer to the questions that some of Your Honors just posed, during discovery, it was denied that anybody else had mistreated her. It was denied. She was asked to say what were the acts of discrimination, who
but
did when.
Was any issue raised about pornography?
Not properly, Your Honor.
Well,
let me please try to address that. There was the discovery closed, and then it went to where the parties were writing their briefs at the MCAT. At that point, Pelletier's brief, which was 10 pages, talked about Cabral for 9.5 pages, had 1 paragraph about Playboy and Penthouse magazines being in trucks and being in dispatchers' desk drawers. No affidavit in support, no evidence, never raised in discovery, never brought up in the depositions and so forth. The MCAT struck that. Now, that is not proper evidence that was brought before the MCAT at the proper time. Now, Chief Justice Marshall asked about affidavits. Specifically, there were no affidavits at the MCAT until after the lack of probable cause finding. And I suggest to the court that that is a bright line key date that draws the line right there under the Everett case. That you can't have people say, oh, lost the lack of probable cause finding, so now I'm going to bring in this, that, and the other thing to try to make a stronger case. Too little, too late. That sets all of the MCAD regulations and all of this court's pronouncements about jurisdiction and administrative exhaustion at naught. If you can then just try a whole new matter and then
I take it she could have brought a new complaint, but it may not be timely, or
all those issues. You're right, Your Honor.
Mr. Dowd, let me ask you this: at a certain point, a complainant can file in the Superior Court, right? You don't have to go through the entire MCAD proceeding.
Correct.
Right?
Yes.
If we go your way, aren't we essentially treating with disfavor people who go through the MCAD proceeding?
No, Your Honor, because
certainly on the basis of these allegations in Superior Court. She'd made claims, and then she did discovery or did whatever she wanted to do. Wouldn't she be able to include these claims in her Superior Court?
If those claims were made at the MCAT, they were not. If those claims were made at the MCAT, then you can move over to Superior Court and those people are treated as you said. But if those matters are not raised at MCAT, you cannot opt out and do that. That's the point. While you're at MCAT, these matters are subject to the administrative exhaustion, subject to the MCAT, who are experts in these matters, investigating, trying to conciliate, and so forth.
But just to even if that's the case, does it make sense? If you can leave MCAT after 90 days, there's not much that's going to happen within 90 days.
But the claim is on record.
But the claim may be on record, but on the 91st day you file your complaint in the Superior Court and you raise...
You haven't done discovery.
Yeah. But what's been lost?
What has been lost is that, well, I'm not sure I can phrase it as what has been lost, but what the defendant has in that circumstance that the defendant didn't have here was you're dealing with the same claim. Essentially, you're going over to the Superior Court with what was framed within those 90 days.
But what does the complaint say?
The complaint here says, it's on the appendix at 109, that Mr. Cabral, that he treated me poorly because he said that I wanted the forbidden fruit, and he said that I couldn't use the truck I wanted, and because he reprimanded me for break time.
Would you agree that if the complaint
Did it tick off a box that said sexual orientation?
I think so, Your Honor.
Did it tick off
Frankly, I don't
gender?
recall. I think so. I believe you're... there's no question that she raised sexual orientation as a basis for these statements having been made to her. That is correct.
Well, would you agree if she raised the general issue of a hostile workplace, would that be enough to put MCAD on notice to investigate?
If she said that everybody in my department or
No,
a bunch of people in my
not
department,
everybody.
maybe. But she said, Mr. Cabral said this to me, Mr. Cabral said that to me. Now, I must emphasize, too, Your Honor, a point that I haven't made, where she denied that she'd been mistreated by others. Under oath, in answers to interrogatories,
But you
which
can
she
have a
proposed, is the MCAD supposed to then say, well, nevertheless, despite your denial, we're going to investigate and go on a fishing expedition to see if somebody else might have treated you wrongly.
If he's the supervisor, right, and there are pornographic magazines left in desk drawers, pornographic magazines left, and the supervisor knows that, it might be that nobody else has treated her the way that Cabral treated her. But I think under our case law, there can be a finding of sexual harassment, even though she says nobody else treated me badly. There can be a hostile work environment with nobody, cupping her breast or pinching her or calling her a 5-letter word.
Well, two things would have to be hypothetical. One, Cabral was a foreman. It is not conceded by me or by case law that a foreman is the supervisor for discrimination purposes.
Who was the supervisor?
And secondly, there must be...
Who was the supervisor?
The superintendent of the highway department is the boss.
Yeah,
the foreman just has people working under him.
Well, the foreman is in charge of that particular workplace, correct?
Of these workers under his tutelage. And the second part is
And where's the
that there has
supervisor?
to be the claim and the timely claim and evidence of that porno. And again, that was not there. That was
That's cutting.
one paragraph in a counsel's memorandum at the conclusion of a case should not be deemed enough to raise, to properly raise an issue for MCAD investigation.
May I ask this? Did her complaint raise issues about unwanted touching,
No, absolutely not, Your Honor.
invasions of privacy?
Absolutely not.
All of
Absolutely
that
not.
came in through the affidavits after.
No, some of that even didn't come in the affidavits after the lack of probable cause. Once it went into Superior Court, it mushroomed yet again. And that's when that stuff came out.
Why did
None
the
of
judge let it in?
Say he should
Well,
not
he
have.
decided that he was wrong.
He believed that it was subject to Godier, and I represent that it is not, because Godier, we're talking apples and oranges. One is timeliness, the other is a jurisdictional matter.
I take
and
it
that
you
this matter
objected
should
to
not
all
occur.
of this.
There was objection. I was not trial counsel, but this was all visited before trial through motion in limine, and there was objection to that. Well,
So the judge basically took it back
after the trial.
after trial and was
Correct,
going to
after
grant
the
a new
verdict.
trial.
Correct. Well, no. He granted a remediator or a new trial, which I say is not the proper remedy, because what you have here is if the court concedes, just for the moment, that some of these claims were not properly raised at MCAT and were beyond the subject matter jurisdiction of the court, as I contend, because they were not administratively exhausted. If all of the claims were submitted to the jury, and the jury then just rendered one verdict as to liability on all claims and rendered one award of damages, then I would suggest that that verdict is inherently tainted, because you can only speculate as to whether the jury found that the Cabral incidents, which were before the MCAT, were a matter of liability for the town, and if so, the damages on those.
May I ask you what your position is about whether or not a person who agrees to remediator and then that's appealed by the other side, can they revoke that agreement?
You certainly may ask me, and I hope you don't reach it. It would be my position that it should be a moot point for the reasons we've discussed. But as to whether it can be raised, there are some states that have done that by statute. There are some states that have done it by rule of procedure or court rule. There are other states that have not decided, or other states that have gone the other way. And going back to 1889, there's U.S. Supreme Court authority to the effect that if you accept a remediator or an additor, that you then cannot appeal. So I would suggest...
Even when the other side then appeals?
As to that, this is what I'm saying, that there are some states allow it, allow that.
Mr.
I would
Dowd.
suggest...
Go ahead.
I would suggest that if the court does reach that issue, and that it should hold that it should be prospective only, because it must be emphasized that Bordanza, which didn't decide it specifically, it only hinted at it by citing these other jurisdictions.
What difference does it make if we conclude that you are that your client is entitled to a new trial?
Makes no difference.
I'm looking at the relief that you've asked for.
Yes.
You've asked us to reverse what you call the implicit denial of JNOV. Are you saying that the actions of Cabral did not rise to the level of discrimination?
Absolutely.
Okay.
And I think that is a threshold issue that I would ask the court to visit, because if conceitedly those matters were raised at the MCAT, I think those should be looked at.
If you take just the one example that is quoted, about you want what men have.
Yes.
Cabral testified to one thing. I mean, was the judge required to believe that? The jury required to believe that? Why doesn't that go to the jury?
Even if it was a disputed matter.
It goes to the jury.
I think that
Don't you think it goes to the jury?
The court is the original gatekeeper.
No, don't you think that goes to the jury?
I do not, Your Honor, because viewed in the context, in comparison with the cases which have gone to the jury.
It's a factual dispute, but as to
Right.
what a reasonable person could interpret. Doesn't that go to the jury?
Well, a DV is denied, and then it goes to the jury, and that is when I say that the JNOV is a proper remedy, because at that point, the court looks and says, would that statement and those other things support a reasonable jury verdict? And as to that, I respectfully say no. I mean, you look at the other cases where statements have supported sexual harassment claims, and they've been, outright propositions, sexual propositions, or vile racial epithets, not a biblical reference to a forbidden fruit. And in the context where it was undisputed that he had just told her, do not take this truck, and then she took it, and he said, you want the forbidden fruit. That was the truck, was the forbidden fruit. I'm sorry, Your Honor. I got to roll.
No, I guess I'm asking you whether you think the facts of other cases we have to take as the floor, that nothing that reaches the level of some egregious case will make it.
No, Your Honor. It's up to this court to determine what the floor is. And I would suggest that this does not get up over that floor. These are bona fide personnel actions, and we've got a foreman who he's reprimanding her for taking something.
Bona fide personnel actions?
Yes, Your Honor, because the comments an issue.
To refer to a truck,
I'm sorry, Your Honor, I didn't hear you.
To refer to a truck as forbidden fruit?
Maybe I have too thick a skin, but in the context.
Maybe it's your gender.
No, Your Honor, respectfully, I would say no. I've got my daughter here, for goodness sakes. I'm
I'm not
attuned to...
suggesting that you're a sexual harasser. I'm just saying that we look at it from the person in the plaintiff, the complainant's point of view.
Well, in that case, Your Honor, I would say that you have to look at context. And I would add, too, that by plaintiff's own admission, this man, Cabral, had never, in all of the years she'd worked in his department, never said anything to her that was sexually offensive. She didn't even think that was sexually offensive. By her own testimony, she said that it wasn't until she talked to a shop steward a couple weeks thereafter that he told her, well, that's a sexual comment. So in answer to your question, Your Honor, maybe it's just not just my skin. The fellow who was with her coworker, and this is all in the record, a fellow named Martin was with her when the statement was made. Didn't bother him. He didn't think it was sexual. It wasn't until the shop steward weighed in a few weeks later. So no, I do not think respectfully that would get over the floor. I think that is not trial worthy.
Thank you, Mr.
Thank you, Your Honor.